Welcome to Employment Law This Week. I'm George Whipple. Today we'll discuss the issues to consider when hiring from a competitor. When an employer is faced with this situation, the first step is to find out whether the applicant has a restrictive covenant, non-compete, or non-solicitation agreement. Here's Epstein, Becker, Green's Kate Rigby.
Sometimes an employee or an applicant will tell you that they don't know if they have a restrictive covenant, whether it's a non-compete or a non-solicitation. And when you're the hiring employer, you really want to run that down. And so what you can suggest doing is asking them if they have access to their file already.
Kate talks about this topic in detail on Epstein, Becker, Green's new podcast series on trade secrets and non-compete law. It's called Spilling Secrets, and it's available now on the Employment Law This Week podcast feed. She recommends looking at any employment agreements the applicant has. Sometimes these restrictive covenants can be in offer letters. Sometimes they're in stock option agreements, in handbooks, or policies. So review as much as you can and have an experienced counsel review any agreements to assess litigation risk. Epstein, Becker, Green's Erik Weibust picks it up from there, recommending that the litigation analysis when hiring from a competitor should start with the agreement itself, assuming that that is possible. Employers should then evaluate whether the applicant would be taking a competitive position at their company, whether the location of the role could be an issue, as well as other factors.
For instance, is there new management in place that feels the need to set an example? Have there been a lot of employees leaving recently and they feel the need to staunch the bleeding? Has our company been hiring a lot from that company such that there's bad blood between these two companies?
Look at your history with the competitor. Is there a record of cross-hiring that has established some good faith? Do you have any sort of collaborative working relationship? It's these types of intangible considerations that you need to understand because you can't guess what's in the mind of the competitor. Employers should also consider whether the position in question can be restructured to avoid the restrictions. Perhaps their role can be tweaked so that the position is not competitive with the employee's role at the prior employer. On Spilling Secrets, Epstein, Becker, Green's Millie Warner provided some good ideas for when restructuring is not possible.
If that's not an option, perhaps the hiring employer could consider placing the incoming employee on the bench for a period of time. I mean, it depends on how long restrictions are and, whether the hiring employer can wait, but, often just waiting it out may be an option. Another option is a buyout. If the hiring employer, could pay to essentially buy the book of business and the practice that this incoming employee has. That's one way to resolve this, which, is something that could be explored from the outset or even in the midst of or after the litigation and settlement.
Subscribe to the Employment Law This Week feed wherever you get your podcasts to hear the full audio episode and to catch all future editions of the Spilling Secrets series. Thank you very much for watching, and we'll see you next time.